But I really do appreciate the time to be able to talk to you all about the lawsuit. And Bill has told me that some of you may be new in the crowd, and so asked that I kind of start from the beginning. So I'm going to try to put up, and hopefully this will work, a slideshow that goes through what's going on in the lawsuit and tells you kind of where we started and where we're at. And you know, I know all of you have lived with the Checkoff for many, many, many more years than I have. And so this probably started for you well before these ads that I'm putting up right in front of you now. But for us at Public Justice, this is what caught our attention. The transfer of individuals' money to major corporations to advertise things that major corporations should be paying to advertise, right? These are not ads for beef, these are ads for Weber Grill and Arby's and those companies who should be paying for their advertisements themselves. You know, this is not, the government should be not get in the business of taking taxpayer money and moving it over to corporations. And when we began to think about what we could do about that, we started to look at the Constitution. And many of you are, again, probably very familiar with the background of these suits, but there seems to be something to us innately wrong with the idea that people should have to spend money to advocate for others' views, others' work, rather than for their own views and their own work. And that's really what the Supreme Court said back in 2001 in the first of these Checkoff cases. That's United Foods case that you see up at the top here. And the Supreme Court said it's just that basic concept that the First Amendment not only allows me to speak to you, but it also prevents the government from telling you what you have to say. And it prevents the government from telling you that you have to support someone you disagree with. Just like the government couldn't pass a tax saying, you know, we're going to support the Constitution and have the ACLU decide where all that money goes and give it all to public justice. I'm sure plenty of people would, you know, object to funding public justice out there, right? That's their right. That just like that can't happen, the government can't force you to support the beef Checkoff if it's against your interests. The wrinkle there is that in 2005, the Supreme Court invented this new concept called government speech. And it really was a new concept that they invented in 2005. No one had ever heard of it before. And it's quite frankly still a very new constitutional concept. We're not totally sure of all its contours. But the basic premise is that when the government is advocating for something itself, it can take your tax dollars and do that. And, you know, there's some sense to that. You know, there are plenty of government programs that it requires the government, it must be able to tell people about. And every time someone objected to that, they could raise a constitutional challenge. That would be a problem, right? We'd have a hard time getting things done. And so the Supreme Court said there has to be an exception to the general principle that you can't fund things you don't want to, or you can't be forced to fund things that you don't want to when it's government speech. And they said that at the federal level, the Checkoff is government speech. So when the beef board operates, it is engaged in government speech. Quite frankly, I think that's a questionable concept. And if I were to bet money today, I would guess that the Supreme Court would not reach that holding again today. The problems with government speech have been highlighted over and over again in recent Supreme Court cases. The contours of the court have changed. My guess is that holding doesn't stand up today, but it's the world we live in. And so when looking at what we could do, we started focusing not on the beef board side of the equation, but in this whole complex mess of other flows of money that are in the Checkoff. And, you know, I think I'm not sure how well you all can see this chart. I'm not sure how big the screen is, but the fact that it has to be this complicated to just get money out of your pocket to the government, it must tell you something weird's going on. This looks like a shell game. It looks like someone's trying to set up a scam. And that's what it really is. And you don't need to take our word for it. This is a beef board document that I have up in front of you. And what it says, I'm not sure whether you can read the fine print, is that the state beef councils make their own individual fiscal program decisions. So while half of your money, half of the dollar you pay for every head goes to the beef board, and the Supreme Court said that's okay and we can't touch that, half of it stays with these entities, these qualified state beef councils, that by their own declarations are making independent, individualized program decisions. That means they can't possibly be the government. And they can't possibly be engaged in government speech. And for those of you who have served on the boards or who have worked with them, you know this, that we've done some investigations, and in plenty of states, RCAF members can't even attend the meetings until our suit in Montana. The Montana Beef Council held meetings in secret. We couldn't find out when they were occurring. We couldn't find out where they were occurring. We couldn't find out what was happening at them. No minutes were released. The Montana Beef Council's organizational documents, it's a privately organized entity, basically say that if you are from pre-selected NCBA affiliated entities, then you can serve on the Montana Beef Council. But if you're from any other entity, you can't even try to serve on the Montana Beef Council. An entity that's getting half of your money to do that can't possibly be advocating for government programs. They're advocating for their own programs. And that's what we argued when this suit started back in 2015 and 2016, and that's what we won on. We focused on the Montana Beef Council, and we said that when an entirely private entity is taking taxpayer money and using it to generate whatever it wants, that cannot be constitutional. Even if you have this exception for government speech, even if you recognize that the government must support its own program, sometimes it can't force you to turn over your money to a private entity you can't even attend the meetings on. And that's what the court agreed with. It said that explicitly. And the other thing it said, based on a new set of Supreme Court doctrine, is that the government can't just paper over this with an opt-out scheme. And after we filed, the government ran around and said, well, we're going to fix this by just saying, well, the producer can send all their money onto the beef board if they choose. In other words, we're going to place the burden on you, the producer, to secure your rights, and we'll violate them until you tell us that we can't violate them anymore. And the court fully rejected that. It said, no, if a private entity, if the state beef councils are not entitled to get the money in the first place, then you have to affirmatively agree to give them the money before they're allowed to use it. The government can't try to get by and put a lot of burden on you and stop you from exercising your rights. Rather, the government has to get your consent before it turns over any of this money to these private entities, these state beef councils that are privately formed, that only are made up of NCBA affiliates. And we won that again in 2017. So the government took its first appeal, and the government actually appoint and be able to remove the people who sit on the council. One of the things that really defines government speech is that the government actually selects the speakers. That, we expect that when the president appoints someone, he's appointing the person he wants to appoint. And if that's true, then that person is reflecting the president's views, or at least the president has control over that. Similarly, if the government wants the state councils to reflect their views, to be engaged in government speech, to be exempt from the First Amendment of the United States Constitution, then it actually has to take the time to appoint people it wants to reflect its views, because then you can hold your government officials accountable. You can say, well, if you appointed this person to the council, you must agree with them, and they're saying X, Y, or Z, and I disagree. Why do you agree with that? But in the current situation, the government can just say, well, that was out of our control. We didn't know what they were going to say. We didn't know what they were going to do. And the court said, when that's the setup, that council, those state councils, cannot be engaged in government speech. And the government appealed again, and we won again. The government appealed to the Ninth Circuit, the Court of Appeals, just below the Supreme Court. And what the Court of Appeals said is exactly right. Every case that's held that government speech, an entity is engaged in government speech, the government appointed the people actually engaged in that speech. It appointed the people who were going to choose and decide what speech was going to happen. And it again refuted the government's argument that it can place the burden on you to protect your constitutional rights. If the government wants you to fund the private state beef council and it's not willing to take the time to appoint the people who are going to serve on that council, if it's not going to take the time to ensure that council is actually reflecting the government's views rather than NCBA's views, then you have to affirmatively say you want to participate in that before the government can turn your money over to them. Otherwise, the money has to be spent in a constitutional way. Government can't place the burden on you. Well, with all of that, we went back down to the district court. And actually, I think Bob might have understated slightly. We now are litigating against 15 different state beef councils. So when we started, we were really focused on Montana. That's obviously where RCAF's home is. And when we started the case, what had happened was the Montana Beef Council had run a Wendy's advertisement. Wendy's does not even commit to getting beef from the United States, let alone Montana. And we said, that's ridiculous. The state council can't possibly be engaged in government speech. Well, when the government defended the suit, what it said is all these councils are treated exactly the same. And so with the argument you're making, just, it isn't limited to Montana. And we said, okay, great. If it's not limited to Montana, we're going to expand the suit to other states. If all the states are identical, we're going to treat all the identically situated states the same and say that you should not be required to turn your money over to other state councils beyond Montana if they're private, if they're not engaged in government speech. And these are the 15 states that you see up there that we're currently litigating over. Some of you might wonder why we chose these 15 rather than others. What's unique about these 15 is they are absolutely entirely private entities. All of them are set up as private entities. They have no government role whatsoever. No state government official, no federal government official ever created these entities, ever gave them a charter. They're 100% completely private. They make their own determinations about who can serve on their boards. For instance, in Kansas, the Kansas Livestock Association, which is an affiliate of NCBA, has ultimate determination of who can sit on the board. The president of the Kansas Livestock Association is always on the Kansas Beef Council board. And so that's why we focused on these states. We focused on them because they're absolutely private. There's no way the government can say it has any role in selecting, appointing, choosing these people. And then we said that can't possibly be government speech. And that's the argument we entered into. And we're now in a phase, we just wrapped up a phase of the case called discovery. So when we had all these initial wins, we're doing this based on just basically the language in the statutes, the language of the Constitution, the language of the Supreme Court decisions. But when we went back down, the government said, no, 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 there's much, much more information that you need to understand, and that will prove that all this is okay. And a bunch of the state councils being funded by NCBA, and we know this for a fact, their lawyers are being paid by NCBA rather than the state councils themselves. But NCBA paid for lawyers, supposedly representing the state councils, also intervened and said, no, 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 you're not understanding what's going on here. You don't really get it. We're going to produce all this evidence to you to show you what's really going on. Again, this may be hard for you to see, but let me tell you what we found in that evidence. We found that not only are the state councils continuing to be appointed solely by their private selection procedures under their privately selected doctrines, which now everyone admits in the case, the government admits, the state councils admit, we found that they continue to develop their own speech. Particularly, the councils go on junkets across the world to go talk to various foreign entities and bring foreign entities to the councils to talk about what they think should be going on in the beef trade. Government never even thinks to talk with the councils about what that speech is, what they're going to say, what those talking points are, what the policies are that they're going to propose. Councils continue to do that entirely on their own. The other thing is the government turned over to us their document about how they review quote unquote government speech, how they approve and decide what's government speech. That document's a farce. It's a joke. What it shows is that the government will say anything is government speech as long as it doesn't contain expletive and it agrees with the government statements about what's high and low cholesterol and other kind of health claims. The government doesn't actually review the state council's speech. What it does is it places a rubber stamp on that speech to make sure that it complies with some very narrow health and safety policies of the government, and then lets the state council say anything they want. But probably the most interesting thing we discovered are these investment documents, something I know Vaughn's familiar with, and probably others of you have seen, but maybe some of you haven't. Almost every state council fills one of these out at the beginning of every year. And through them, millions upon millions of checkoff dollars are transferred not only into the state council's hands, which are private hands, but from the state council's hands into other private entities' hands. What you may not be able to see, but what this document says is that the Texas Beef Council in 2018 gave $1 million unrestricted to NCBA. It gave another nearly $500,000 to the United States Meat Export Federation. As Vaughn just was describing to you, the USMEF is a privately created entity that's run almost exclusively by CEOs of major meatpacking companies and other meat companies to promote their agenda. Every single one of the councils that we're suing over has a document like this in the center that's turning over hundreds of thousands, if not millions of dollars a year of your checkoff money to other entirely private entities. And what it says at the bottom is that those entities can do anything they want with the money as long as it quote unquote promotes beef in their view. So as long as they can claim that it's promoting beef according to them, they can do whatever they want, and they only have to report at the end of the year what they actually did with the money. After it's all spent, after it's all gone, after they've done whatever they want with it, they'll tell you at the end of the year. And funnily, we actually said, well, okay, show us what they tell you at the end of the year so we know how they actually spent the money. They can't figure it out. The government has no record of where the money actually went. The state beef councils who paid the money gave us one of those glossy annual reports you sometimes get in the mail that talks about how great an organization is and how what it's doing without actually telling you how they spent every individual dollar. There's no accounting, there's no budgeting. They just get this glossy report that says the USMEF is doing so great. And that's the only way they track these multiple millions of dollars. I mean, we don't have all the sums, so I can't give you an exact figure, but I guess it's in the tens of millions of dollars going from the private state beef councils to the other private entities, USMEF, NCBA, as well as state entities. So the Wisconsin Beef Council, for instance, funds the Wisconsin Livestock Identification Initiative, which promotes tagging, which I know you guys talked about yesterday. The other thing we found, and again, this is probably less shocking to you, is right, the councils produce speech like what I have here on the side about from Texas. No one would possibly know that this beef-loving Texas ad is a government speech document because it says it's coming from the Texas Beef Council, and the Texas Beef Council is an independent entity. And so they're hiding who's actually supposed to be accountable. So you can't tell your friends and neighbors what's going on clearly, so you lose your ability to build political support. And that's now the focus of our case. We're making the same arguments we did in the past. The government has to appoint and be able to remove the people on the councils for them to be engaged in government speech. Otherwise, you shouldn't have to fund them. But we're also drawing out the government has made no real effort to supervise these councils. The councils are allowed to hide what's actually going on and present the speech as private speech, even though it's supposed to be government speech, and then you can go to your government official and say, you should be accountable for this, you should be doing something about it. But most importantly, we've been emphasizing it's a shell game. It's a shell game exactly like the original map I showed you suggested, just works. The money's not just going to the state councils. The state councils are transferring millions upon millions of dollars into other private hands. And that's where we are. We submitted our last brief to the court a couple of weeks ago. The government and the NCBA-funded interveners get to submit their briefs in a couple of weeks. Because of random assignment, we got assigned to a magistrate judge, which is appointed by the court to hear cases in the first instance. And so he will decide that case after argument on October 2nd. We're going to go out to Great Falls and argue the case on October 2nd. No matter what happens, the district court judge, the Article 3 judge, has to prove the case, and so there will be another round of briefing. Almost certainly, there will be an appeal. Our hope is that at that point, we already will have an injunction to stop funding the state beef councils. So your money will no longer go to those same 15 state beef councils, but we'll have to obviously see what the court does. I think part of the reason that NCBA is paying for these attorneys to quote unquote represent the state beef councils is so because they want to try to go to the Supreme Court eventually. And so we will have to be fighting there eventually. Our hope is that this case is so clear and so extreme, the Supreme Court wouldn't take any other interest. But once all that's done, I think there are really 3 steps to begin to think about. We have steps 1 through 5 in hand. We will be planning this and doing this. It'll take some time, but we will get it done. The question is then, how do we deal with the other states which aren't entirely privately selected and appointed, where there are state beef councils, which are state-created entities? While less of a concern for those of you in this room, I do think for public justice, one of our concerns is how do we deal with the other checkoffs that are harming other producers throughout the country? I got a call from some rice producers in Arkansas a couple of weeks ago that are having the exact same experience that you are, that the rice checkoff is being used to fund major corporations and their policies and procedures and advertising rather than things that benefit the producers, and the producers are losing out. How do we help them? But I guess where I would encourage all of you to focus on is what are some really exciting legislative proposals that are going on right now. All this started with Cory Booker and Mike Lee's proposal around the checkoff. I think Elizabeth Warren's proposal that came out a couple of weeks ago is yet more exciting. This is getting attention in the current presidential cycle. The checkoffs have become an issue that people really are paying attention to and are concerned about. And I think what the next step really is going to be is a reform system along the lines of what RCAB has been asking for years: regular referendums, lack of conflict of interest. And that's something you can start pushing for with your legislatures right now, and is a really exciting moment for this to be getting so much attention. And so with that, I will stop. I think I'm pretty close to my time anyway, and let you ask any questions. I am told that you have mics in the room, and so I want to be able to make sure I can answer any questions you may have. I apologize if I can't see you, however, because I can only see part of the room.
Bill, you got the mics? Well, while we're waiting to get the mics here, I guess I have one question. I know it's ongoing litigation, and maybe you can't answer this, but maybe you'd like to describe exactly what that memorandum of understanding was between the USDA and Montana Beef Council, and also what has happened to the funds that the producers are requested to send to the CBB rather than be spent by the Montana Beef Council.
Yeah, so thanks, Vaughn. That's a really helpful question. So probably some of you have heard about these memorandum of understanding, MOUs, that have been going on. After we won the first couple of rounds of the suit, what the government said is, well, okay, our opt-out procedure, placing the burdens on producers isn't going to work. So we're going to enter into these MOUs with the state councils to try to cover up what we're doing. And what those MOUs say is that every advertisement that the state council puts together has to be approved by USDA. But that's exactly what the discovery that we took showed, that when USDA says it's quote unquote approving an advertisement, it's actually not making sure that the advertisement contains the speech the government wants it to contain. It's not taking responsibility for the speech. It's going through the most rote technical review of the speech possible. The only thing they look for are expletives or directly racist statements. Those are the only 2 times they could ever point to that said they took things out of state council's documents because they were either used a racial slur or an expletive. And the other thing they check for is making sure that nutritional facts are correct. That is, that when you say something's low in cholesterol, you're actually phrasing it correctly, consistent with what FDA, USDA, and the FTC require. And that review does not cover any of these foreign marketing trips that we've talked about, nor does it cover at all the multiple millions of dollars that are sent to these other third parties, NCBA, USMEF. Those materials, which are funded by the state beef councils, don't get reviewed at all. So that's what's happening with the MOUs. The MOUs are really just a papering over of what we knew throughout, which is that the money's going from your pocket to private, corporate-oriented speech. And to Vaughn's second point, one of the interesting things that's come out is that while the Montana Beef Council keeps on complaining about the fact that the suit is preventing advertising from occurring, preventing your money from being put to use, it turns out that's actually at the request of the Montana Beef Council. So we found out a couple of months ago, that when you refuse to turn your money over to the private Montana Beef Council, as is your right, that money's supposed to go to the beef board, and that money's supposed to continue to promote the checkoff as best it can in a way that is constitutional, because that's the best we can do right now for you in terms of the law. But it turns out that they're so annoyed about our success, so hoping to kind of turn money back over to these private entities. In Montana, your money hasn't been going to the CBB at all. It's been going into a separate private account where it's not being used at all, because their hope is that eventually they'll be able to reverse the case and turn the money back over to the Montana Beef Council. So all those complaints you may read about in the press about how RCAF is stopping the checkoff from being funded, that's just a lie. It turns out that what's happening is that the Montana Beef Council is stopping the checkoff from being funded because it's hoping it can take your money to put towards its private use later in the day.
Thank you. Does anybody else have any questions?
Yeah, I'm David Frank, and I want to make a little statement first, but I want to thank RCAF for putting up on this checkoff litigation. And I want to thank David Wright for putting me on the checkoff train. Because of him, you're looking at the former president of the Kansas Beef Council. And how did I get that job? Well, because the president of KLA, Kansas Livestock, appoints the board. How did I get on there? I own the Kansas Beef Council. It was not a private entity. I went to the Secretary of State and registered. So now, because of Mr. Wright, he got me all stirred up here, I got sued. So, and being sued, they wanted to put a gag order on me. As you can say, I'm not stopped talking. I'm going to keep on talking. So my question was on that, I do redirect too. And that started up that way too. So, but there's something different. Montana, to redirect back to the Beef Council, it's just one redirection form per year. I have to redirect, every cattle receipt receives a redirection form. I can put one form in a letter, send out 3 receipts, and they'll send back 2. So what gives there, I do now have a final statement on USDA reform to redirect. And it's even more complicated than ever before. But I would like to make a comment on, and I think you answered about the Western Livestock reporter made that comment where, about Montana's not getting the money that they should have. Where, and you made the comment, where is that money is in a checking account somewhere? They wrote that article there. Well, I challenge her to change that. Where is the money? Well, it's because it's supposed to be used to redirect. Why is it in the checking account? So you pretty well answered that one too, but I want to thank everyone.
Yeah, let me just underscore that. So we did, when we read that Western Livestock article, Bill alerted me to it. We reached out to the Department of Justice to ask what was going on. And the Department of Justice response was that it was the beef board's decision to not spend the money that was being sent from, the producers were saying, don't go to the Montana Beef Council, go to the beef board, that the beef board decided to not spend that money in hopes that we will lose our suit, and then they can then send the money back to the Montana Beef Council. And that's the official government statement on this. They are choosing not to put any of that money to use in the interim. And that's, my understanding is that is in order to benefit the Montana Beef Council, that the hope is that the Montana Beef Council, a year or 2 from now, if we lose, we'll get an influx of many millions of dollars that came from your pockets. But it has nothing to do with RCAF's suit. RCAF's suit is about ensuring that producers have the option as best as they can under the Constitution to direct how their money is going to be spent. Under the Constitution, you are entitled to not give your money over to private entities. And that means you, unfortunately, and I do think it's unfortunate, you don't have the option not to send it to the beef board. You have to send it to the beef board, but you do have the option to either make a choice, send it to the beef board or send it to the state council. And if you like what the beef board's doing, great. And if you don't like what the beef board's doing, send it to your state council and put pressure on your state council. But what's been happening is that they've been trying to undercut that choice by saying your choice doesn't actually matter. What we're going to do is we're going to hopefully beat you in court, and then we'll wipe away the choice you made to send it all onto the beef board. And as to your question about redirection, so the way our suit in Montana worked, we first got a preliminary injunction against the Montana Beef Council. And so what that says is that you have to agree to hand money over. To make life as easy as possible for them, they declared, and they said this on their own, they didn't ask us about it, that you would just have to say that once a year. But I do think it's ironic that when they want you to opt out, which is currently the rule in all the other states, and that's what we're suing over, we're trying to make it opt-in, you have to agree. But currently in all the other states, you have to opt out and say you don't want your money to go there. They make you do that every month. They make you do it every month with your receipts, and you have to submit those receipts by the 15th day of the following month after the sale's made. As I've heard from numbers of you, it's next to impossible for some of you to do this. You don't have the receipts. You can't get it in time. And so it is ironic that they claim that's not a burden. And that's what they're arguing in court when they clearly understand it's a burden, which is why they made the Montana Council a once-a-year thing. And final thing I'll say before I let the next person ask a question, if there is one, is just thanks you for your comment. We rely extensively on a variety of comments and statements from the various RCAF members in the audience, and I'm sure elsewhere, to support this suit. We've relied on declarations from you. The stories we tell are your stories. We've been telling Al Cisco's story a bunch. That's your experience that makes the suit live and important, and thank you for your comment and your time.
Vaughn?
Go ahead.
Vaughn, the comment that I made was, oh, I'm sorry, I'm Dave Wright. Sorry, Dave, I'm Dave Wright. Vaughn, the comment I made was that this is a money laundering scheme that Al Capone would be proud of.
Right. I thought
It's not a shuffle, it's a money laundering scheme.
You're absolutely
Did you catch
right.
that, Dave? It's a money laundering scheme. All right, so anyway, what I want to touch on is this. I did 8 years on the Nebraska Beef Council and 6 years on the Cattlemen's Beef Board. And about 4 or 5 years ago, when I was reading this act and order over and over again, if you read in the Act of Congress, the actual act, under Section 8, paragraph C, it makes it totally clear. It says that the producer will receive a credit if he leaves money at a state beef council, up to 50 cents. So there's the opt-in was written into the law. Producers could opt in to leaving money at a state beef council. That verbiage corresponds in the order also. But the beef council's never given us the option to opt in up to 50 cents. They've always just taken 50 cents. We could leave a nickel. We could leave a penny. We could not give any and give it all to CBB. So I asked the lawyer who wrote it, Wayne Watkinson. I cornered him one day and had a discussion about it. He told me that that credit is a fictitious credit. And I said, really, you're telling me Congress passed a law with a fictitious credit in it? Have you ever looked, that's what it says. It's plain and clear that if you want to leave money at a beef council, so it's an opt-in program, but it's always been pushed on to us as it's a mandatory that we've got to do it. And that applies to all states except for those that had state checkoffs before the act and order took place. So that's how you can catch the other ones other than the 15 that you got.
Yeah, so that's absolutely right in terms of the language. What the government has repeatedly told us, and they've said this openly, is they believe that allowing the state councils to take the money by default is the equivalent of you opting in and is a credit. I agree with you, it's totally inconsistent with what the meaning of the word credit is. And I'll actually go you one better and say, if you look at the Supreme Court decision in Johans from 2005, the very first footnote says that the Supreme Court was led to believe by the federal government at the time that you all made a voluntary contribution to your state beef councils, and therefore it was not going to address those voluntary contributions. It's hard for me to see how you being required to turn money over and then allowing to strip 50 cents out is anything close to voluntary. But that is the position of the government currently, and that's why we're litigating in court rather than this all just being solved through government action. I mean, that they have taken the position that the credit exists by them just taking the money.